Welcome everyone, and thank you for joining us today on Level Up Law, where we here at South Carolina Legal Services are leveling up your legal knowledge on the different areas of law that we handle. I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services, and I'll be the host of the webinar today, along with our producer, Kenneth Elliott from our IT department. We are joined today by South Carolina Legal Services Housing Law Unit Head, Attorney Mark Fessler from our office in Greenville. Mark will be walking us through the new eviction online classroom that we hope will help attorneys handling evictions, as well as those who are representing themselves. As you view today's presentation, please do remember that this is not legal advice, but just general information for the public. This classroom hasn't actually been published yet. We've been working on it for quite some time with a nice grant from Legal Services Corporation. And so we're looking forward to sharing it with you today and hopefully getting some good feedback so that we can launch it as soon as possible. Again, thanks so much everyone for joining us. And Mark, let's check out this great new tool from South Carolina Legal Services.
All right. Thank you, Susan. Thank you for that introduction. And you really covered sort of the gist of what we're going to try to get into, which is our new residential eviction defense classroom. And hopefully y'all can already see sort of the landing page for that right there. But let's turn now back to the classroom. So, in thinking about putting together legal information to put it out to the public, one thing we wanted to do is we wanted to provide information that was more in-depth than what you might typically find when you just do a random Google search about evictions in South Carolina. And we also wanted to make the information specific to South Carolina law because, although every state has evictions and has laws, they differ from time to time, place to place. And so having something that is unique to South Carolina, specific to South Carolina, was important for us. And we also wanted to create a classroom that tried to answer some of the common questions we get and maybe resolve some of the common misconceptions that people have about, what a lease is or how eviction works and things like that. And so what the classroom is, South Carolina Legal Services, we've already created a number of classrooms, and we host them on this website called lawhelp.org/SC. And you can see the classrooms that are already available for public consumption, from debt collection, guardianships, getting your landlord to make repairs. And when you click on a link to one of these classrooms, it'll take you to the same sort of landing page that we're going to go over for residential eviction defense. The only difference is the eviction defense classroom is not public, whereas if you wanted to learn about getting your landlord to make repairs, you can do so. So I just wanted to give you an idea of where that will be once it does get published on our Law Help website. So, the classroom starts off with an introduction. It talks about, we're going to talk to you about the basic steps that you can use if your landlord sues you for eviction. And it consists of individual lessons. They're formatted in an FAQ type setup. So, what laws apply, what are the reasons somebody can be evicted. And the classroom really assumes that you're at the beginning of the legal process. But let's dig into the classrooms a little bit. So the first lesson is sort of what laws apply. The laws that apply to an eviction are three: the lease, state law, and if you live in a federally subsidized property, federal laws also come into play. If you wanted to rank those, the lease is probably the most important. State law sets certain baselines. So if parties don't have a lease or if it's not written down, state law will add some lease terms. Some of those lease terms can be modified or waived by a written lease. So really the written lease is the place that you want to start for determining what your rights and the landlord's rights and responsibilities are. However, if you don't have a written lease or if the written lease leaves out some terms, state law comes in and under the Residential Landlord Tenant Act supplements a written lease and also has other terms. And so we have linked here a convenient link to the South Carolina Residential Landlord Tenant Act. You can pull it up. It's fairly long, but it's here and you can review the law that the magistrate, that the landlord, everybody is supposed to be following. Also, state law controls how evictions operate, the nuts and bolts of the actual process. how to file a lawsuit, how to affect service on a tenant, and things like that. And we've also linked that set of rules, that statutory section here as well. It's under South Carolina Code section 27-37-10. And so you can review what the actual law says about how the process is supposed to work. And federal law has a lot of complicated rules and regulations depending on which particular program you're in. It goes far beyond the scope of what we're trying to do or able to do in this particular classroom. And so we recommend that if you have a federally subsidized connection, public housing, a housing choice voucher, that you seek out counsel from an attorney to advise you on those particular situations. So what does the law say about why a tenant can be evicted? There are 3 reasons that a tenant can be evicted. 1, a failure to pay rent when due or demanded. 2, the lease term has expired. Or 3, the tenant has breached the lease in some other way other than non-payment of rent. Each of those different categories have different considerations that need to be kept in mind. So with the failure to pay rent, the general rule is you're required to pay on your due date. Most leases have a 5-day grace period, and state law has a sort of built-in 5-day grace period. You still may be subject to a late fee if you pay after the due date, but there's a slight grace period there. The due date should be written down in your lease, but if you don't have a written lease or if the due date is not written into the lease, then state law supplements that term or adds that term to the contract, and it says that you're required to pay monthly at the beginning of each calendar month if your term is month to month, or it's less than month to month. If your rental agreement does not say what rent you're supposed to pay, the law says you must pay the fair market rental value for using and occupying the property. So if you're renting property and there's no specific agreement about what the rent should be, you still have to pay something, and the law says you have to pay the fair market rental value. Of course, determining what that is may not be easy, but it's not nothing. The lease term ending. So if you don't have a lease agreement that says how long you can rent the property for, then the law presumes that your lease ends at the end of each month and begins at the beginning of the next month. That's called a month-to-month lease. And that continues on until one party gives the other party written notice that the lease will not be renewed 30 days in the future. If you rent a room or rent by the week, then the lease ends and renews week to week. If your lease does set out a specific term, say 3 months, 6 months, 1 year, then the lease ends when the term ends. Now, sometimes you'll want to check your lease because a lot of times leases might modify that. It might say, well, this lease is for 1 year, and at the end of that year, it goes month to month. It automatically renews month to month. So in that case, the lease doesn't automatically end. But if a lease does not have a provision of automatically renewing itself, then the landlord is entitled to simply, at the end of the lease term, say, all right, your lease is over. We want you to vacate, and that's permissible. However, if the lease does end, but the landlord still allows you to remain there and paying and to keep paying rent, that probably triggers the creation of a month-to-month lease. Then finally, the tenant can be evicted for a material breach of the lease. And I think this is important because not any breach of the lease can justify termination of that lease. The lease has to be breached in a way that is strong enough or significant enough that the law calls it material. And that means that it really goes to the heart of what the landlord-tenant relationship is, such as, having unauthorized guests might be a material breach of the lease. Damaging the property or letting the property, fall into disrepair, that could be a material breach of the lease. But an example of a non-material breach, I think, would be if the lease says something like the tenant is supposed to replace all light bulbs in the unit. Then the landlord inspects and finds one single light bulb burned out. The landlord can't turn around and say, well, you've breached the lease, we're going to evict you, because I would be surprised if any court found that to be a material breach of a lease. So then the next classroom discusses what does a landlord have to do before filing an eviction lawsuit. And the key thing here, as you saw in the video, is notice. The general rule is that the reason for the reason a landlord gives for terminating a lease has to be documented in some form or fashion in a notice. And the rules for terminating the lease, again, are found in the lease itself. So there's usually a provision in there that says, here's what happens if you default, or here's how the parties can terminate a lease, something to that effect. South Carolina Residential Landlord-Tenant Act talks about what you can do to terminate a lease. And then again, under federal law, there are some federal rules that come into play that we don't really have the opportunity to get to. The kind of notice the landlord has to give you depends on the reason the landlord wants to terminate the lease. And so remember, the previous lesson was there are only three reasons: non-payment of rent, end of lease term, or a material breach of the lease. So if you have failed to pay rent, the type of notice the landlord has to give you is one 5-day notice. That only has to be given one time during the entire time you're a tenant in the property, according to state law. And the non-payment of rent notice has to say something to the effect of this: if this is your notice, if you do not pay rent within 5 days of the due date, the landlord can start to have you evicted and you'll get no other notice. Now that language, or language similar to that, can be written into your lease. And if that language or language similar to it is in your lease, and the law also says that it has to be conspicuous, so it can't just be written in the same text, in the same format as the rest of the lease. It needs to be drawn out or highlighted, bolded, something like that, to set it apart. But if that language is in the lease, then that's the 5-day notice, and you're not entitled to a separate written 5-day notice. But if the landlord does not give a 5-day notice and rent goes unpaid more than 5 days past the due date, the landlord cannot terminate the lease until they've given one notice. If the landlord wants to terminate the lease because you're at the end of a lease term, the landlord may or may not have to give a notice. Again, like we were talking about, for leases that are not month to month, that just are 3 months, 6 months, a year, those end on the date that the lease says it ends. And there's no notice required to terminate that kind of lease unless the lease has an automatic renewal provision, or unless the landlord has continued to accept rent well beyond the end of the lease term, which would convert it to a month-to-month lease. So look at the lease to see if the landlord has to give any kind of notice to terminate a lease at the end of the lease term. And then finally, material breach of the lease. If the landlord wants to terminate a lease because of a material breach, something that the tenant does that the landlord claims violates the lease or violates the tenant's obligations under the Residential Landlord-Tenant Act, there's something called a 14-day notice, a right to cure notice, as it's commonly called, that's in the Residential Landlord-Tenant Act. And this means that if you have a violation that does not materially affect health and safety, then you basically get one opportunity to fix that problem or to not re-offend, let's say. So, for example, if you have an unauthorized guest living in the unit, you should get one 14-day notice saying you've got an unauthorized guest, that needs to be resolved. And the landlord cannot terminate the lease without giving that 14-day notice. If the issue is damages to the property, then the tenant has an opportunity to fix those damages within 14 days, or to at least start the repairs if they're going to take longer than 14 days, and pursue the repairs in good faith during the 14-day window and complete them in a reasonable time thereafter. So those are for material breaches of the lease that do not affect health and safety. If you breach the lease in a way that threatens health and safety, the landlord can require repairing, replacement, or cleaning the damaged items as quickly as conditions require if the issue is an emergency. So let's say you're renting a single-family house and the lease requires you to maintain the appliances, which is permissible under state law if you're renting a single-family house, even if the landlord provides them. And let's say there's a problem with this, a gas stove, and there's a gas leak issue. The landlord could require that to be fixed sooner than 14 days because clearly that would pose a health and safety risk. The landlord does not have to give the 14-day notice for non-payment of rent, or if you are conducting illegal activities or permitting illegal activities in the dwelling unit. So those are the notices required under state law. Federal law also has some additional notices for people who occupy Section 8 or public housing. Those notices are much more detailed than the ones required under state law and go beyond the scope of what we're presenting here in this classroom. So let's move on to how an eviction starts. So after a landlord terminates the lease upon giving proper notice, then an eviction is allowed to begin. An eviction lawsuit begins once the landlord goes to the magistrate court and files something called an application for ejectment. The state of South Carolina, the judicial department has put together sample forms that are used. And so we've linked to those forms, and you can see examples of what the documents are going to look like. So if we pull up the application for ejectment, this is what the landlord has to file, or this is what the landlord will fill out when he goes to, or he or she goes to the magistrate court. It says, I, so-and-so, am the plaintiff, state that I'm a landlord lessor. I further state that a landlord-tenant relationship exists between myself and the defendant, whatever the defendant's name is, and then the grounds for ejectment. And it's sort of a checkbox, but it's one of those three grounds. Fails or refuses to pay rent, the tenancy has ended, or the terms or condition of the lease had been violated. So the landlord files that, and then based on that application, the magistrate will issue something called a rule to vacate or show cause, which looks like this. And all these, of course, blanks would be filled out. And the landlord says that to the tenant, to the defendant, the landlord is asking the court to evict you from property located at, and I'll give you a property address, because, and then it should include the same information that the landlord put in the application for ejectment. And then it says you, the tenant, are required to do one of two things. You either have to vacate the premises, or within 10 days, you have to contact the magistrate. It'll have the magistrate's contact information within that 10-day period for the purpose of scheduling a hearing to show why you should not be evicted. And at the bottom here are some entries for where the sheriff or magistrate's constable who serves the rule to vacate is supposed to note the attempts made to serve it, and then finally the date of service, because the date of service, again, will trigger your 10 days to respond. So we have those documents linked at the bottom of this lesson. And, it's pretty straightforward. That's how an eviction action starts. So once you get served with the rule to vacate, you have 10 days to respond to the rule to vacate. This lesson, I'm not going to go through it in detail, but it kind of gives you the ins and outs of how service of a rule is supposed to operate. We get a lot of cases where we ask people, well, when were you served with the rule, the rule to vacate? Well, I don't know. It was on my door today. I found it today, but they said they served it 3 days ago. So there's a lot of confusion about how service is supposed to happen. And I think that, it's not just a tenant thing. I think perhaps some magistrate courts or constables may not be entirely serving it correctly. They're supposed to make 2 attempts to serve you in person. They're not supposed to just show up and paste it on the door and leave. They're supposed to make 2 attempts to serve you in person. And if they can't get you in person, those in-person attempts are supposed to be separated by, some time. They can't, do it at like 10 o'clock and then try it again at 11 o'clock. But if they can't get you twice in person, then they're supposed to mail it. And 10 days after the mailing date is when the 10 days to respond starts. But if you're served in person, the 10 days starts, of course, on the day you get served. So how do you respond? The way to respond, kind of what the statute says, is that you have to appear and show cause. So magistrate courts have different, policies about whether they'll allow you to require you to file something in writing or not. Some magistrate courts do require something in writing. Other magistrate courts may allow you to just pick up the phone, call the court, and request a hearing. What I would recommend before you do either of those is decide whether you intend to seek legal advice or legal representation about your case. Because if you go ahead and contact the magistrate court, they're going to schedule a hearing, And that may prevent you from certain rights like requesting a jury trial. And so it's best to go ahead and use the 10 days to seek legal counsel if you intend to do so. So let's move on to some possible defenses that you might have in an eviction action. So the video mentioned some common ones, being that you didn't do what the landlord says you did. I didn't have an unauthorized guest. I have a friend that visits frequently from time to time, but he's not living here. You did what the landlord says, but that doesn't count as a breach. So, the landlord says you have, a dog, but there's nothing in the lease that says you can't have a pet. Nothing in the house rules that says you can't have a pet. You didn't materially breach the lease, or the landlord didn't give you all required notices. So those are some common defenses that we look at. Another common defense is called waiver. So what a waiver is where if one party is aware that they have a legal right, so if the landlord is aware that you breached the lease, and the landlord is aware that they can then take steps to terminate that lease, and they don't do it. They say, well, don't worry about it, or we'll overlook it this time. The landlord can't come back later and say, you know what, I've reconsidered and I want to hold you accountable for that lease violation. In that kind of context, the landlord would have waived the breach, and that is a valid legal defense. And so then we give, an example of a situation where the lease says you cannot have somebody living with you, and then, the landlord knows the friend is occupying the property. The friend later moves out. The landlord can't, months down the road say, you know what, I want to evict you for having that person living there who was not supposed to be living there. And in any event, the landlord is still required to give you the 14-day notice advising you to have your friend leave the dwelling. Now, we often get the question about, well, either I withheld rent because the landlord didn't make repairs, or, just the landlord hasn't made repairs like I asked. What can be done about that? In those kind of situations, it's possible that you might have something called a counterclaim if your dwelling unit is not fit and habitable and it's the landlord's fault. So going back to our classroom on getting your landlord to make repairs, that classroom goes into detail about what the landlord's obligations are in terms of keeping the property fit and habitable, and what you must do to ask the landlord or to get the landlord to make repairs. So this lesson right here really is more useful in the broader context of that other classroom. And so, and we've linked that classroom right here, so you can click over there to refresh your memory, or to go over sort of what you need to do to get the landlord to make repairs. One thing that comes up is the repair the type of thing that the landlord is required to resolve? And generally speaking, the landlord is required to maintain the property fit and habitable, but there's no precise definition as to what fit and habitable means. And the landlord is also supposed to comply with building codes requirements that affect health and safety. At a minimum, these things mean that the landlord has to make sure that essential services in the house work. Essential services are defined by law. Essential services include running water, hot water, heat. Note there that it does not include air conditioning. Air conditioning is not defined as an essential service. If the landlord does provide a working AC unit, then usually the landlord is required to maintain that AC unit in a working condition. Essential services also include sanitary plumbing and sewer systems. So, no leaking toilets, no leaking pipes, etc. Those stopped up sewer systems, operating electrical systems, and gas, if gas is used for heat, hot water, or cooking. The landlord is supposed to supply and maintain any appliances that are necessary to provide running water, heat, hot water, electricity, and sanitary plumbing and sewer. And then if the landlord provides appliances, the landlord is supposed to maintain those appliances, because it's presumed that that's part of the rental agreement, that you're not just renting the house, that you're also renting the appliances provided with the house. But the rental agreement, the law allows that the rental agreement can exclude these appliances in certain circumstances. So appliances needed for essential services cannot be excluded. So you can't say that the tenant has to maintain the HVAC unit if it's necessary for heating the building. So what happens if the landlord does not fulfill these duties to maintain the property? Generally speaking, the tenant has to give proper notice before a tenant can make a claim for damages against the landlord. How that ties into an eviction is a claim for damages could be used to offset unpaid rent. So if the landlord is suing you for unpaid rent and you have a claim for damages, the one can offset the other. And if at the end of the day you owe nothing, or if the landlord owes you, then you should not be evicted for unpaid rent. And again, referring you back to the classroom on getting your landlord to make repairs, that'll give you information on how to do that. How do you assert a counterclaim? So a counterclaim is a particular type of legal action where you're claiming against the person who is suing you. So an eviction in legal speak is in a sense called a claim, and you're filing a counterclaim to that. To raise a counterclaim, you have to file a written answer with the magistrate, or if you go to the magistrate's court and you say, I have a counterclaim, the magistrate court rules say that the magistrate court or their staff are supposed to take down and write down your statement. And at the end of this lesson, I'll show you what a counterclaim form looks like, because the court administration, South Carolina Judicial Department, that is, has created forms that you can use. To prove your counterclaim, you'll need to think about what you need to prove your counterclaim. You need to be able to explain exactly what the repair is. So you can't just say, I asked for repairs and they were not made. You should say, I asked for this repair, that repair, and be able to list them out. You should be able to explain what notice you gave to the landlord about the need for repairs, and also when you gave that notice. So if your evidence is, well, I talked to the maintenance man one time, it might have been last month, it might have been 2 months ago, that's not great evidence. Ideally, what you want is something in writing with a date of when you wrote it out, somewhere you can prove when you delivered it to the landlord, because the landlord also has a 14-day period to make repairs before the landlord can be responsible for not making repairs. You also need to know what your damages are. So even if the landlord failed to make repairs, if you have not been damaged by that, then you wouldn't be entitled to any kind of recovery, and therefore you wouldn't be entitled to any kind of set-off. So you need to know these three things at the time or before you file your counterclaim. And so if you want to file a counterclaim, this is a copy of what that looks like. If I can drag it over. And again, these forms, they're also found on the South Carolina Judicial website under their form section. And so it says the defendant has a claim against the plaintiff in the amount of X dollars, the counterclaim, and then you just sort of summarize what the counterclaim is about, and you file that at the magistrate court. How do I prepare for court? Even though evictions are called summary proceedings, meaning they're supposed to happen quickly, they do require preparation because it is a trial. And there are many things that can occur. It's difficult to know exactly what's going to happen at a trial. There are some instructions that the South Carolina Supreme Court has approved for use. These instructions are supposed to be served to tenants with the rule to vacate or show cause. There's a specific South Carolina form number here. So they're supposed to be served with you, and they give you information, just very basic information, such as the court will not telephone a witness, the witness has to come in, the court will not reschedule a witness because a witness is unavailable if you have not subpoenaed the witness. It talks about how to issue subpoenas or how to request the issuance of a subpoena, etc. So those are some basic instructions. But I think the two things you want to keep in mind is you want to know what your argument is, and you want to prepare your evidence to support that argument. And you want to be very conscientious about keeping things separate. So really, you should write down an outline of what you want to argue. If the landlord claims you didn't pay rent, write down what your defenses are, such as I did pay rent, or the landlord allowed me to skip this 1 month and allowed me to catch up later. So the fact that I didn't pay March was not a breach, or the landlord waived that breach. If you have multiple defense, write them all down, because this is your only opportunity to get out your defenses to the magistrate. Preparing your evidence is also very important. Not only must you know what you want to argue, but you have to have the evidence to prove it. You must be able to produce testimony or documents that will support your claims. Testimony can come from you, or it can come from any witness on your behalf. If you plan to testify, take time to think about what you want to say in order to prove your defense. For example, if the landlord claims that you breached the lease by letting somebody live with you, and your defense is that the landlord knew all along, then you will want to talk about how, what's the first time the landlord met the guest? Does the landlord, the landlord knows the guest by name? You'd be able to describe other situations that could prove that the landlord knew about the guest and let it go. Also, the more precise you can be with dates and times in conversations, the content of conversations, that is, the more credible you're going to be. Because a lot of this might come down to a he said, she said. So if you say, well, you let me do X, Y, and Z, and the landlord says, no, I didn't, the magistrate has to make a decision as to who to believe. And the more precise somebody can be with the dates that things happened, specifics about what happened or what was said, the more credible that person is going to come across. Also, if you plan to have a witness testify, be sure you talk to the witness about what the witness actually does or does not know. I mean, you may think that somebody knows what happened because they were there when a particular incident happened. But if you haven't talked to the witness and say, what do you recall about this? Who was the person that used that that curse word? It wasn't me. The landlord claims that I used the curse word, and they're trying to evict me for disruptive behavior. But what do you remember about what was said? Be sure to talk to the witness and understand what the witness is going to say, because if the witness is going to say something that hurts your case, you're going to be stuck with it if you allow that witness to testify. And finally, as part of the preparation, be sure you have documents that you want to use. So if the issue is non-payment of rent or payment of other monies, you want to have copies of receipts, canceled checks, bank statements, money orders, things like that, to show where you did pay, the date you did pay, so that you could challenge that. If the landlord has, for example, a no pets rule in the lease, but you have texts where you say, hey, my friend's dog is over here, or something like that, and the landlord says, okay, no problem. You want the text. So basically, you want to try to document, everything you can in case you're going to need it later on at an eviction hearing. If you lose at the eviction hearing, what happens? So if the magistrate court rules against you, or if you have a jury trial and the jury rules against you, the next step is for the magistrate to issue something called a writ of ejectment. A writ of ejectment is a document that will be obtained by the landlord and then posted to the property. This is an example of what this is what a writ of ejectment, this is the authorized form for what a writ of ejectment looks like. And it basically says that you have 24 hours to voluntarily vacate the premises, and if the premises are not unoccupied after 24 hours, a deputy sheriff may enter the premises using only the force necessary to effectuate the ejectment. This is, writ of ejectment. This is also the order that allows law enforcement to conduct a set out. So like the writ says, it has to be served to the property, it has to be given to the tenant, or it can be served in person or by posting it on the front and back door or in the most conspicuous place on the building. That starts a 24-hour clock. 24 hours later is when the sheriff's deputy can come back and actually effectuate that ejectment at the property. Law enforcement does have some discretion to extend the ejectment if there's an elderly or ill tenant, but it's up to the deputy's discretion. Who knows whether they will or will not exercise that. And then finally, let's talk about what do you do if you lose, but you disagree with the court's decision. Basically, you can appeal. You have 30 days to appeal to the circuit court. You have to file something called a notice, fill out a notice of appeal. You then have to file that appeal with the circuit court. you have to provide a copy of the appeal to the magistrate court. And not until you do that does the writ of ejectment get stayed. So you have to file the appeal and serve it on the magistrate court and also serve it on the landlord, that is, before that writ of ejectment will be put on hold. Once the writ of ejectment is put on hold, the court will hold a what's called or require you to fill out an undertaking. You can fill out the undertaking and submit it with your appeal. That's probably the best practice. Some courts will hold a hearing after an appeal is filed to order the tenant to continue to pay rent while the appeal is pending. Because if the tenant misses a rent payment while the appeal is pending, then the tenant loses the right to appeal and the appeal gets automatically dismissed. So that's very important. And that's the undertaking. It's filing the appeal and then filing the undertaking will trigger a stay of the writ of ejectment at the end of that lesson. And then we just talked about this a little bit. If I file an appeal, can I be put out? No, if you file that bond or that undertaking, that puts the writ of ejectment on hold. And as long as you pay your rent within 5 days of the due date, you should be good to go. And then finally, we'll have a link to the materials and forms that we've had throughout all the other lessons. They'll all be linked at the last lesson there. And so with that, that is the end of our classroom. We hope to launch that later this year and put it up on that Law Help website later this year. And we hope it'll be very useful. And if you have made any notes or have any feedback that you can provide us or would like to provide us, we'd love to hear it.